Welcome, everyone. Again, good afternoon. I'm Allison Schaberg, Consolidated Planning Group, and I am excited to be here with you today. We are excited to talk to you about a special needs attorney and a special needs financial planner, and what are the differences and why you might need both. And so we have Melissa Donovan here today with us with the Wewell Law Firm. And they are out of Austin, Texas, and we have had the pleasure of doing a couple presentations with her in the past. She's a wealth of knowledge. So, Consolidated Planning Group, we are a holistic special needs financial planning firm. We're going to go deeper and wider on that. We provide a lot of educational webinars for families of special needs. We want to get the information out there. The journey is tough and there's a lot of moving parts. And as we have kids that are getting a little bit older, transitioning, or they've kind of crossed over transitioning, there's a lot of questions because of how things change once they turn 18. So without anything further, we're going to go ahead and get started. And Melissa, I'm going to turn it over to you. Thanks for being with us, Melissa.
Thanks for having me, Allison. It's nice to get to see and chat again. So as Allison said, I'm a special needs attorney in Austin, and she had so graciously asked me to come back and speak with her again today, which is always fun. But this is a question, I know, Allison, you probably get this a lot too. I certainly get it from time to time with clients. We're doing some estate planning, or we're doing special needs planning, we're doing guardianships. And the question is, well, why do I need both of you? Can't you just do all of it? To which my answer is always no, I can't. None of us can do everything. But technically, I think I liked what you had said, Allison, in prior conversations. If you want to share with the group your very brief explanation of this entire presentation today.
Yeah, we summarize everything in the first minute of the presentation. But what I like to say is, so when it comes to a special needs attorney or a special needs planner, what is the difference and why do you need both? And the bottom line is the attorney is the paper and the legal documents, and I'm the money. Okay. So you got to have the legal documents. They've got to be in place and they've got to be right. It's not a do-it-yourself type thing. Okay. As a family, I have 4 kids. I have 2 with special needs. I have one that's kind of transitioned into adulthood and one that's still a minor. So I've been in your shoes, but as it relates to these things, we have specialized circumstances. And so when it comes to these situations, we need a specialist. So, and, forgive me, Melissa, but all attorneys are not created equally, and neither are all financial advisors. And so because you have a specialized situation, you need someone that is experienced with special needs, not one of those people that say, yes, I can do that, where they kind of dabble in a little bit of everything and they know a little bit of nothing when it comes to special needs, because you can really accidentally really make some royal mistakes that can have long-term impacts. So that's it in a nutshell. So let me kind of I think we kind of talked about, so when it comes to the special needs attorneys, you're providing the legal advice. So give us some examples of that, Melissa.
So when it comes to the way that we would say, what is providing legal advice? This is information that is particularly fine-tuned because we have experience and education and all these things behind us, not just letters behind our names. And I know Allison has a bunch of letters behind her name too, just different letters. But essentially what we're talking about here is taking a particular person's specific circumstances and comparing them against specific laws, regulations, Medicaid rules, Social Security rules, and being able to provide the advice to say, okay, this is where you are. This is what is an available option to you in terms of benefits. How do we fit those puzzle pieces together? And then what legal tools do we need to utilize? Trust, do we need guardianship? Do we need all these things that you would require an attorney to be involved in helping you with? Which this particular slide hits on pretty well. So in terms of legal documents, we kind of go through there. You've got your trust, you've got wills. People kind of generally think about estate planning and things like that. Not all of us as lawyers are the Perry Masons and, the Jack McCoys of the world. But in terms of being an attorney and helping with legal advice, we do get into conversation because some people, I think you had said earlier, Allison, a question you get a lot is, do we need guardianship and how do we start that and things like that. And those are the things that an attorney is going to be able to guide you down in terms of, let's say you have a 16-year-old, a 17-year-old, you're starting to get concerned about that. And you've heard at, 17 seminars that you've been to that everybody needs a guardianship, which is not altogether necessary. I know we had done a seminar a few months back on that, but that's where a lawyer's legal advice comes into play to be able to tell you, okay, these are the circumstances. Maybe you do need guardianship. Maybe you don't. Maybe a supported decision-making agreement. Maybe your child does have capacity to sign powers of attorney and things like that. That's kind of where the attorney kind of comes into play and helping the client make those determinations.
And I think too, Melissa, again, like you said, kind of these, mid high school years, guardianship can be applied for 6 months, prior, you can start that process. 6 months prior to the child turning 18. And if you miss the 18 mark, you can still come back and have those conversations with an attorney. But the biggest questions that we get all the time when it comes to legal stuff is always surrounding guardianship, the special needs trust, first party and third party special needs trust. Why do I need one or the other? Which one's right? Which one's wrong? Do I need both? And then of course, this magic age of 18, all of a sudden your child maybe hasn't qualified for anything through the years, but now all of a sudden they're going to possibly qualify for SSI and Medicaid, and you don't know what you don't know about that, and that's okay because you're not alone. It's very confusing. But how do we not mess this up? So talk to us about the first party and the third party special needs trust.
Yeah, absolutely. So the way I like to explain when I'm sitting down with a client, special needs trust, is if you think way back to being in like 8th grade, 9th grade, when you used to do, or 7th grade, we used to do those quadrants about, the way that things are passed on hereditarily, and you've got the axes on the top and the bottom, and you've got these different things. It's kind of the best way to picture special needs trust. You've got your first party and your third party special needs trust on one axis, and then you've got your, what I call standalone trust and testamentary trust on that top axis. And then we kind of put all those little puzzle pieces together. The main thing with a first party trust is that the idea with that is that we are actually putting in what most of your situations are, your child's money into that trust. And the main key piece there is that because it is that individual's money, the person who's going to end up applying for Medicaid, for Social Security, the negative downside of that is that it is always going to have what's called a Medicaid payback provision. Basically what that means is when that person passes away, if there's money left in that trust, most of it's probably going to go back to the Medicaid office before it can go on to siblings, children, other family members, etc. Versus if we're having a third party trust, we're putting mom and dad's money into a trust for daughter, son, whatnot. That's not going to have that Medicaid payback provision. And we would never in a million years want to put mom and dad's money into a place that's going to have a Medicaid payback provision because it's completely unnecessary. It was never your child's money to begin with. So those are the types of conversations that we have a lot too in terms of clients. And some people do need first party trusts and some people don't. And a lot of times you start out not needing one, but then eventually down the line, something can happen where your child will need one in the future, or maybe an ABLE account. Those are really good tools too.
So when it comes to this first party trust, I think there is a lot of confusion because you said, if it's the kid's money, okay, that they need a trust. But so some things that we've seen along the way of the kid's money is the kid, maybe there was a settlement of some sort. We've had medical malpractice or other things that we've seen before where there might have been a settlement. That's one example. Mm-hmm. We've seen another example of scholarship refunds, which would be the kids' money, right? Mm-hmm. Can you give some other examples of the kids' money? Is there earnings?
So it could potentially be earnings, but
not usually.
Every situation is a little bit different, but not typical that it's going to be earnings. Usually if we've got an earnings issue where that money is going to be, accumulating over time, many times an ABLE account, and I know you're familiar and can help people with those too, can be a better use of or place for that money. But many times it is going to be a couple of things. Like you mentioned, the big one is medical malpractice issues or accidents where there's a large settlement coming in and that has to have a place to go. It's going to go into a first party special needs trust. The other two big ones are what I would call mistaken inheritances, not in the sense that the child made a mistake in getting it, but that whoever passed away didn't put in the effort and or didn't know and give that child some money outright, which is disastrous to benefits. So in that case, when that child's set to receive that inheritance, there's multiple things that can be done where that money then gets put into a first party trust for that child. Or the other one, which is, in my opinion, less common that people are aware of, but a bigger issue, is child support. And the issue here is that technically once the person turns 18, even though mom or dad is the one getting that check, it's technically the child's money. So that money is going to count against them for purposes of Social Security, Medicaid, and it really does need to be directed into that first party special needs trust in order to not negate or cause issues on those Medicaid benefits.
So that you hit on that, and that is a huge thing. And unfortunately, divorce is something that has happened. And with the number of people that we have on here today, you might be in that situation. And the thing is just know that if your child support order is that the child support will continue post 18 and you have a special needs child, just know whether you're mom or dad, you're the payer or the receiver, it needs to be redirected. And even if you guys don't like each other, it's for the benefit and the well-being of the child for it to be redirected to a first party special needs trust. And if you don't do that, they're basically not going to qualify for SSI and Medicaid. So as parents, we're hurting ourselves and we're hurting the kids, if that is the situation. You mentioned one other thing that, so we were talking, what was the thing that you said right before, it escaped me, right before this, the child support? Oh, grandma and grandpa. That's what I want to talk about.
Yes. The unintentional inheritance.
Yes. I'm sorry. I wanted to circle back on that because I talk about that in a lot of our other presentations of the grandma and grandpa have their down home financial advisor and they've worked with them forever. In fact, they may even have the same financial advisor that their own parents had. Anyway, but they're not nuanced and special needs and they don't know and they mean well. Okay. So these are having what I like to talk to our clients about is having these deliberate conversations with our loved ones of saying, look, I'm not assuming anything, but we've been, working on special needs planning and we've learned some things to do and not to do to make sure that we preserve, benefit eligibility for little Johnny in the future. And here's what we learned. Because grandma and grandpa want the best for him. That's why they're like leaving money. But so the bottom line is so at the end of the day, in this example, is what I want to ask is that if grandma and grandpa did leave little Johnny money directly to him, then basically what they do, they're a family, and their next step is to reach out to an attorney. And then you guys go through the process of getting it redirected and a court order for a first party special needs trust. That is what is going to, the only thing that is basically going to allow them to maintain their benefits. Now, I think we've got some questions coming in and I'm going to see.
So,
okay. So if we die and we get our life insurance, where does that go? And that's, if it's directed correctly, it goes to the
third party trust.
Correct.
So this is the way, I love it when Allison tells me that I'm correct every day.
I'm so excited. Well, you know what?
You know what? Super excited about this stuff.
It's the beneficiary, the issues with the beneficiaries that we're seeing all of the time. And so that's, so carry on, please.
So this is definitely one of those things where I go back to what we were kind of saying right at the very beginning, where it is so important that you do not just have a special needs attorney, but you are communicating with your financial advisor, and hopefully a financial advisor like Allison, who does special needs financial advising. Because, and I tell this to all of my estate planning clients, not just my special needs situations, but any kind of beneficiary deshigration is known as a key point that is going to throw off an entire estate plan, whether we're dealing with this, standard typical plan, or we're dealing with special needs, but especially in a special needs scenario, because I can't tell you how many times I've seen it happen where, we do all the planning in the world, or, someone else had done planning with a client, mom and dad did everything right. And they, they got their wills, or they got a trust, and they have third party special needs trust in their estate planning for their child. And then they forgot to designate that trust on the beneficiary designation, whether it's on the retirement account or the life insurance policy. And if you do all the special needs planning in the will or in your, revocable trust for Johnny, but then you've got the life insurance policy sitting out there that has $500,000 and you name Johnny, we've got a massive problem when mom and dad pass away. So it's really, really important. The short answer, I know attorneys are known for this. We never give short answers and we love to say things like, it depends. But the short answer to the question is that money should go to a third party special needs trust. The very, very long answer that I've just given you is that we want to direct it to the right way. You need to make sure those beneficiary designations are updated properly so that you are directing it on the beneficiary designation into that third party trust that you are choosing to create for your child.
So to clarify, because we have some stuff in the chat box, someone said, wouldn't that money left from grandparents to the loved one be put in a third party trust? And the answer would be yes, if grandma and grandpa have their beneficiary designation set up properly to go to the third party special needs trust. But if grandma and grandpa or grandma and grandpa's financial advisor name your child outright as just a named child, no, supplemental needs trust or third party trust, then the only option is for it to be redirected to a first party special needs trust or lose SSI and Medicaid. Is basically that. So the bottom line is when it comes up, your special needs attorney understands these things and they're going to have these important conversations with you on these things, to how to talk to other family members that might be leaving money, how to set your beneficiaries up, because a lot of times when it comes to beneficiaries, people fix them and forget them. I've even seen ex-husbands and ex-wives get big sums of money because, or people say, I've got that all taken care of in my will. Well, you may have a lot of things taken care of in your will, but when it comes to beneficiaries, it follows what's on the contract for life insurance and new 401k, all of those types of things. So it kind of goes there. So let me see. I think we did have one other question I wanted to make sure that we addressed. Oh, someone said, so when it comes to the Medicaid payback, when does Medicaid dip into it? And basically it's at the death of your loved one. That's and that's one thing that we get a lot of questions on, and I don't go deep and wide with this, Melissa. There's a whole page of calculations and how they calculate what they take back, and I don't think I could spend this time explaining that, but you can read it. It's on the Social Security Administration website on the paybacks. So and then you've got your thing here, only a licensed attorney can prepare these documents. So this is, again, there are like this whole DIY thing. Okay, I'm all about some crafts and DIY and stuff like that. But when it comes to legal documents and LegalZoom and these things on the internet that you can download your own documents, I personally have seen a lot of bad things that have happened as a result of that. So I don't recommend that. I really recommend truly working with a professional. And then the other side of it too, what I like to mention is that I've also seen like legal, not trying to rain on these like legal clubs, like there's legal clubs out there, right? And a lot of times what I've seen, while a legal club, like this thing, you get this group legal service through your group benefits at work or something like that. They might be good for a speeding ticket or a small infraction of something of some sort. You're trying to kick a tenant out of your, rental property or something like that. But what I haven't seen is overly specialized attorneys as it relates to special needs in these groups. And what I have seen is a lot of very new to the industry attorneys in there. So I would just say, I'm not saying that they're all like that, but I would say that a lot of them are. So choose carefully and really look at it, before you kind of go down that highway.
Yeah, you absolutely want to look at who you're talking to. And again, like you were saying, Allison, not to say that there are not diamonds in the rough anywhere. But one of the things I usually tell clients is listen to the words that people are using. Are they saying, I do this regularly? Or are they saying, I can do this? I could do this. Then you kind of know you're dealing with someone who might do it from time to time, or is able to look it up, but might not have the background. Either way, there's wonderful attorneys, there's wonderful financial advisors like yourself. There are people who are more specialized and people who are less specialized. And many people are willing to say, I can, or I'll try, who don't maybe have the experience behind them.
Well, and one of the things that I thought was eye-opening for me is like the UT Special Needs Planning Conference for Attorneys. I actually attend that. I'm not an attorney, but like it's such valuable information that comes out, and the changing of the Texas laws and how that relates to Medicaid. There's a lot of moving parts. It's not just static. That was my takeaway. And you got to be on it, because like there could be like this one little blurb that the little Social Security Administration requires to be in the document. And if it's not there, or if it's written improperly, then it fails to qualify, in the eyes of Social Security as a special needs trust. And then you got issues, and you could be in a payback situation to the Social Security Administration, which nobody wants. I don't care how much money you have. Nobody wants that. So
no, absolutely. And it's interesting because you mentioned that UTCLE, the Special Needs Trust one, they do another one, the NALA conference in August, which is more so typically focused on guardianship and things like that. But the thing I like to impress upon clients is very similar to what you were saying, because things can change so quickly. The example I always give clients is several years back, the head of HHSC actually announced a complete change in how they deal with retirement accounts for, mostly in the long-term care program. It still is not actually codified into the MEPD to this day. So if you have an attorney who doesn't attend those CLEs, who doesn't pay attention to things like that, this is 3 years later now that this has happened, and they still might not know that there's been a drastic change in that, because it's still not in writing. There's a lot of people that work within Medicaid who don't know that that's how they're supposed to apply those rules. Right. So it's very, very different than most things when you're dealing with special needs.
For sure, for sure. All right. So kind of going a little bit deeper, we kind of hit on Medicaid and the Social Security regulations. Talk about some of the other things. One thing that came up in the chat box that I wanted to mention, and actually sorry that we hadn't already brought this up, but what if I die and my child isn't 18 yet? And so this is an important conversation that we have all the time, Melissa, and it's basically the beneficiary mindset. And so here's the typical mindset. And so what I'm about to say, if it's you, it's okay. You're not alone. Okay. And you can still fix it. Okay. So the mindset is if I'm married, if I die, my spouse is going to get the money. And if I have a contingent or a secondary beneficiary lined up, I basically say, if I die, my spouse is going to get the money. If I die and my spouse is already dead and gone, then that's easy. My kids get the money equally. Okay. So that's pretty much what we see all the time. And again, if you've done that, you're not alone. But what we caution against, and we want our families to think about when it comes to your beneficiary designations, when you leave a minor named, as a beneficiary, basically that money sits in trust for them. So if you just name them, money sits in trust until they turn 18. Well, you got a couple $1 million life insurance policy, and then they turn 18 and they magically get this windfall of money that they cannot, even if they're geniuses like all of our kids are, they can't handle. Right. that amount of money. So the right way to go about it is to either have a trust, which spells out how they're going to get the money, right? Or you could have a testamentary trust within the confines of your will that would fix that, which would, again, that trust would form upon your death, and then it would spell out how they're going to get the money, as opposed to just leaving it outright. So the one issue is the money's locked up, right, and until they're 18. And so clearly, if you die and your kid's 5 years old, then clearly they had a lot of financial needs between the ages of 5 and 18. So that's that issue. So there's real easy ways to fix it, but just be careful with that. Whether you have a special needs child, especially if you have a special needs child, but for any minor children. I mean, do you agree with that, Melissa? I mean,
this is definitely one of those things, and I know it might sound cliche to some people, but an ounce of prevention is definitely worth the pound of cure, because it's just simple. Like you were saying, you can absolutely have, even if you have a will, a relatively simple based will plan, you are probably not going to choose to give an 18-year-old several, even $1,000, let alone several $100,000 to do with what they may at 18 years old. I know the law says you're an adult, but let's be honest, how many 18-year-olds would we classify, financially speaking, as a responsible financial adult? So you might want to keep it in trust and make sure someone else is managing that money, but it's still accessible for them until they're 25 or 30 or, whatever age you might think is necessary. I have some clients that age is 65. You never know. Every family is very
I've seen
different.
it too. I mean, I've seen parents where the parents, yes, there's money and there's money for the kids and they want to pay for college and they might want to pay for a down payment on a house and they might want to fund a wedding. But what they don't want to do is enable their kids. They want their kids to thrive and do the very best that they can and reward thriving as opposed to just taking handouts.
Right.
Can you explain, we had a question in the chat box from somebody that said, what if I have two special needs kids? So what do we do in that example when we're talking about these beneficiary designations?
So you're going to want to, whenever you have any special needs child, whether it's 1 or 4 or 2 or 5, it doesn't matter. You want to make sure that in whatever planning you're doing, you are building in at least a testamentary special needs trust. Testamentary just means it's funded upon your passing. It's not something that you're setting up right now to put money in today. When you pass away, this trust is there. And then you want to make sure that whatever money you're directing, so let's say you have 3 children and 2 of them have special needs considerations, you might have a special needs trust for each of those 2 children. And then let's say your 3rd child is 27 and healthy and doing okay. So your beneficiary designations in that case might be a third to, healthy child, and then a third to each of the special needs trusts in your will or in your living trust for your other 2 children. So the key is that we call it coordinating assets in the estate planning arena. We want to make sure that even things that are not necessarily dictated to go through probate or wouldn't be owned by a living trust are still coordinating with the overall plan. And that's where, honestly, in my opinion, regardless of the situation, it is so important that someone has a good financial advisor that they can work with, because that's what you do. You help your clients in terms of making sure those things are kept up to date and that you're checking on them from time to time to make sure there's no other changes that are coming about. So it's really important that those things are coordinating together.
These things are just accidents. It's not like, as a human being, you're not smart or anything. It's accidents, and it's not working with a specialist. They don't know better. Like, they don't know better until they have a claim, until a kid disqualifies from SSI and Medicaid, that, wow, that was a horrible mistake. And honestly, sometimes we have people and we had somebody in the last week or 2 that emailed a change of beneficiary that they wanted, and it was wrong. I mean, it was just wrong. And we said, so we don't just take that. Okay. So we call back and we say, this is why this is wrong. Are you sure this is what you want? This is what will happen if you do this. And it turns out it was wrong. Okay. And we corrected it, but we catch those things. And I think that matters. I had a question, and we're kind of going back to the child support. What happens in the example that someone has arrears that they're owed in child support? Is it possible to get those redirected to a first party special needs trust in addition to going forward, or not?
So it is going to, I know people don't like this answer, but it is going to depend on the circumstances and, how far in arrears are we? When was the money originally supposed to be paid out? And is it usable too? I mean, I've had situations where somebody has had child support due in arrears, but it's not a huge sum of money and it's able to be spent on something. And I just saw a question. Someone asked, what is arrears? Arrears just means that someone is owed child support and the other party has not paid it. Whether they stopped paying it a while ago and then they started paying again, it's that back payment that other person still owes because at some point in time they had not paid it. That's what arrears, child support being in arrears means, that you owe back payment essentially. So if, let's say, it's a smaller sum of money that can be used on something that is necessary for the child and then it's gone that month, you don't necessarily need to have it redirected. If it's a huge sum of money, then yeah, you're going to want to probably get that redirected as much as we can. But again, it's such a situation that's going to depend on the particularities of the situation when the money was not paid. Was it not paid prior to 18? Was it not paid after the child turned 18? So those are all things that would have to be taken into consideration in making that determination.
Right. Okay. So, and certainly any of those types of large sums and stuff would definitely need to be
Yeah, you want to sit down and
that.
talk to an attorney about the particularities of it. And you may want to talk to, I know some people might not want to go back and talk to their family law attorney, because in my experience with family law attorneys, you know, I've had family law attorneys tell me no matter what, people aren't happy with me. So sometimes I know that can be an emotional conversation to have to go back and talk to the same person about such a kind of negative time in our lives. But it is important when things like this happen that you're kind of going back and talking to, you know, your family law attorney as well as a special needs attorney. And something, just again, going back to that kind of ounce of prevention, it is so important if there is a scenario where divorce is looking like a likelihood, that you have very candid conversations with the attorney that you're working with to make sure either A, they themselves have a good knowledge base on dealing with scenarios and families who have special needs children, or they work with a special needs attorney pretty closely, because that's where things can kind of get a little hiccupy too. And I know in the special needs community, myself, there are other attorneys. There's a woman named Christina who I know, who works really closely with family law attorneys. You know, we're always kind of trying to do outreach and make sure that all of these different types of attorneys kind of have at least a basic knowledge to be able to work with your scenario. But it's really important that you're very candid in those conversations with your attorney and don't try to hide things if that's the scenario, so that they can address the situations up front within the decree too.
I love that you just said that, because I was totally thinking that a moment ago, that and then also, you know, so although Melissa doesn't do, you know, like family law divorces, like that's not what she does, but with her, you know, background as it relates to special needs, sometimes, you know, these attorneys that do the special needs and the guardianship and special needs trust and stuff, they may be able to recommend, and we can typically recommend somebody that can help, and maybe that specialized attorney works alongside your family law. Maybe they consult. There's all kinds of things that happen, but again, it's in the best interest of your special needs child. So whether you guys get along or not, it is in the best interest of the special needs child to kind of cross and talk about all of these things. And your typical family law attorney doesn't know anything about redirecting child support to a special needs trust. They don't know it. They don't think about it. They don't, unless they've actually had a case, one out of their whole practice, that this happened. They often do not know about it. And so you think that you're just, you know, working with the attorney that just knows everything. And again, it's what they've been experienced with. So I think that was really, really great advice. Thank you for that.
Anytime.
And of course, we hope you're not in that situation. So
absolutely.
So we hope you don't ever go down that highway, for sure.
Nobody's going to get a divorce, and none of us are ever going to die.
Right.
And we're also never going to pay taxes. None of those things are going to happen, right?
That is for sure. For sure. So, so kind of, you know, moving along of, you know, where do we come into play? What is a special needs, you know, financial advisor? What do we do? So again, we're the money. We provide financial advice. It could be fee-based or commission-based. We lean more towards fee-based. I'm of the premise of people need the advice. They need to know what they need to do. You know, we're not here to rain on any great relationships that you already have. We can partner with your other advisors. We are fully licensed. That, you know, that is that we do manage assets. We do all of the planning that your advisor does, except for we're nuanced and special needs. Okay, so that's, you know, a little bit different. But we're able to calculate future care cost estimates. We hear from families all the time of like, I don't even know how much I should set aside. Of course, we got to retire for, you know, 25 to 35 years, and I don't know how much is going to be left over. And so we're able to calculate all of that. We can tell you dollars and cents from the day you want to retire to all the way down and the average cost of care. And what I would say to you is that your idea and someone else's idea is different. Some people will move to full care early. Some people would rather be dead than move their child to full care. You know, like, I mean, seriously, anywhere in between. We have transition programs, partial care. There's so many different options out there. And so we can help talk through those options and help figure out the money behind them. We spend a lot of time talking about this already, making sure that you have your assets in the right buckets and not just saying okay, because just saying okay to your assets being in the wrong buckets is going to hurt your child. Okay, and it
So,
might. Go ahead.
sorry, Allison. So one question just on that note, because you're talking about right buckets. One question I do get quite a bit from clients, because we'll talk a little bit about able accounts with our clients, and they'll, the question is always how do I set that up? Is that something that you help clients with? And
So
maybe
yes,
if you could just kind of touch on that a bit.
yes, and we do set able accounts up, and so I mean we didn't go deep and wide with this, but basically, when it comes to SSI and Medicaid, your child turns 18, it's based off of their assets. They can't have more than $2,000 in their name, and if they do, it needs to either be in an able account or a special needs trust. Okay, so we can help set that able account up. An able account has restrictions on how much money that you can put into it annually. An ABLE account does have a Medicaid payback, just like a first party special needs trust. But we often hear about why. Why would I need both? Why do I need a special needs trust and an ABLE account? And in a nutshell, you can pay for food and shelter out of an ABLE account, and you can't technically out of a special needs trust. So while a special needs trust could buy a house outright, they don't do debt service like mortgage payments or rent payments or things like that. So SSI is basically designed to pay for food and shelter, so that ABLE account can pay. Basically, an ABLE account is not very restrictive of what it can pay for, and if it's construed as achieving a better life for the special needs person, and that special needs individual's disability started prior to age 26, they can have an ABLE account. And if it's achieving a better life for that individual, then it can basically be paid out of the ABLE account. It's in a nutshell. And we have whole webinars about ABLE accounts, so I'll move on, but you guys can circle back on the ABLE accounts, and we're happy to chat with you further about that. So again, when we're looking at an individual that might need care for the rest of their life, if you're married, you're looking at like almost like 3 retirements, like 3 sinking funds instead of just 2, right? So we're able to assess current assets, forecast the ability to retire and pay for future care. And I think that matters. And the earlier you start planning this process, the more likely that you're going to be able to reach your goal to retire the age that you want to retire, and be sure that you're not going to run out of money, and to be sure that there's enough money to fund your future care desires for your loved ones. So I think that that's super, super important. So again, we just really provide the best advice on which financial vehicles are going to reach your goals. Again, going back to having the money in the right buckets, and looking at, even from an asset allocation questionnaire, and really what your goals are for the future, we can help you get there. So another thing, so these are just, we talked about the ABLE account, but these are just some other things that we do. We do needs analysis for protection plans and risk management. And what does that mean? Okay, so that's a lot of words.
Sounds like a lawyer.
Yeah,
sounds like something a lawyer might write.
It's a lot of words, but basically, when it comes to funding for a special needs trust, so some people are, independently wealthy. They've inherited millions of dollars. They're just wealthy, and they are funding their trust with their assets. They have plenty of money. Nobody's ever running out of money. Not the trust, not them, whatever. Okay. But a lot of people don't fall into that category. They've worked hard. They've worked 25 to 35 years. They've saved money. They have some assets. But if we're going to spend 25 to 35 years in retirement, it is probable that we might need a good portion of those assets, if not all. Okay. And so it depends on what planning that you've done so far. Do you have long-term care covered? What if you need long-term care? So that comes out of your assets. Okay. But so the protection plans and risk management, a lot of special needs trusts, and somebody had this in the chat box earlier, was, they're funded from life insurance. So basically how this works is I pay for my special needs child's care now while I'm alive out of current income. And when I retire, I do the same thing because I have retirement income coming in. But when I'm dead and gone, then how is it funded? And so what many people do is their life insurance proceeds, their death benefit, is the beneficiary is the third party or supplemental needs trust. And so then that trust is what's going to fund that future care. So anyway, so we manage assets, we set up ABLE accounts. Um, we really do a lot of transition planning, both special needs and life. So like I was saying, the life stages, the changes in life, we're moving to the beginning of the rest of our life. We're thinking about retirement. And so I call that the beginning of the rest of your life. It's like we have these seasons and chapters in our life. It's a new chapter. So anytime as a family or as a couple, you're starting new chapters, we're definitely adept in helping with that. And then we really do a lot of advocacy and through resource sharing and referrals and things, because our special needs community, like, it's broad. There's a lot of people that have that have a family member with special needs. But one thing we struggle with in Texas is, there's not a lot of resources from the state or things like that, or the waiting lists are long. But there are a lot of agencies, there are a lot of organizations, there are a lot of programs out there that are designed to help, and there's a lot of resources out there. So we really like to share those. Um, so we advise on the appropriate funding sources for current and future care. So how many, like, again, what buckets do we take the money from? So it's first having the money in the right buckets, but then where do we take the money from, and how do we not mess that up? Okay, so we do that. And then we really spend a lot of time discussing and strategizing on SSI and Medicaid, SSDI and Medicare, and waivers. And I know for me, like as a parent that went through this, so I'm a professional, this is all I've ever done, this is what I do, right? But as a parent and going through that, when my daughter turned 18, it's tough. It is unnecessarily difficult, and that's why we do these webinars, is so we can help you on your journey for sure. And we can also do a Social Security maximization analysis. So the bottom line is if you have a disabled adult child whose disability in the eyes of Social Security started prior to age 22, they can be considered a DAC on your record. And when they're considered a DAC, when you retire or become disabled, your disabled adult child will be basically qualified for RSDI, which is 50% of your benefit. Your benefit's not reduced, but they'll be entitled to 50% of your benefit. And upon your death, they will be entitled to the 75% of your benefit for the rest of their life. So the Social Security maximization, where that comes into play, is the best, most favorable calculation for you as parents of when to take Social Security. Is it 62? Is it 66? And then whatever months, depending on your year of birth, 67 or 70. And so we definitely calculate all of those things.
So another question that I get from time to time, Allison, with my clients, if this is something that you could touch on a little bit, maybe it's something that you also help with, and kind of closely with the maximizing Social Security. People who have pensions through things like TRS, in my experience, there are a lot of people who don't fully understand all of the ways that they can utilize those pensions. I mean, many people don't realize that you can actually extend your pension, not just for you and your spouse, for your special needs child as well. Is that something that you work with as well?
Yes, we're definitely adept at pension max strategies. And also, to your point, if you're a government employee or a teacher, TRS, there's a few districts, like Austin is one, that their teachers actually do pay in, right? Whereas most of the teachers don't pay in. So there is something called WEP, which is a windfall elimination through Social Security. So basically, what you see on your Social Security statement is not what you get. And so we can help you with all of that. But there are some quirky little things as it comes to those two things of not paying in. Railroad employees, which we don't run into very often.
Yeah.
Teachers that don't pay into the Social Security system, and then government workers. We've seen some TSA and Homeland Security. We definitely have clients that have fallen into that realm, and so there's some different things to look at for that as well. Good point. Let's see here. Okay, yeah, somebody said, how do you spell DAC? And it's a DAC, disabled adult child. And I'm sorry for throwing that around, but it is an actual acronym that they use through the Social Security Administration, and they call them a DAC, and you have no idea what you're talking, what they're talking about.
As your children get older and you throw yourself more and more into actually having to deal with Medicaid and Social Security, you become very, very familiar with lots and lots of acronyms. So we like to use those.
Yes, for sure, for sure. Somebody asked earlier, I wanted to go back to this question. And we have our own opinion, and I'm going to send this over one to you. Why or why not, or can or can't I name a sibling as a successor guardian? I want you to address that, please.
So in terms of guardians for children, there's a couple of different ways to think about this, and there are legal reasons why you may not want to, and then there's also many times more practical personal reasons. I think I saw the question you're referring to, why can't I name my 18-year-old as the guardian for my child? It can be rife with conflict, first and foremost, and a lot of responsibility for someone so close in age to that individual, special needs individual, to have to take on that guardianship role, first and foremost. Someone at the age of 18 is probably, even with the smartest, very responsible person, probably not well equipped to actually become a guardian for a special needs individual. Now, the other side of that is, where in life is that sibling? Is your older child in college? Are they here in Texas? Are they going to Yale? Are they in Ohio? And a judge is going to not be inclined to designate someone who's not close by as a guardian. It's a lot of responsibility that you're putting on someone. Now, I do have clients where, let's say they've got an older sibling, we've got, daughter who's about to turn 18, and we've got a much older sibling, someone's 26, 27, they finished school, they're living their life. And they've had those conversations where the other child has said, I want to do this. If that's the scenario and they're responsible enough to do it, then by all means, that can work. But you want to tread very lightly. And I know that's not a very legal answer. It is much so more a practical and personal answer. But generally speaking, you're going to want to have someone as the guardian if it's a possibility. Maybe an aunt or an uncle, an older sibling, like we were just saying, maybe grandma, grandpa, depending on how old grandma, grandpa are. You want to make sure that whoever you're designating as guardian for your child has not only the mental capability of doing it, but the physical capability of doing it. They have, the word I like to use a lot is the bandwidth. It's like we can all handle only so much in any day. And is the person that you're thinking really able to handle that responsibility? And siblings are tough because the other side of it is you want the siblings to be able to be siblings. And you don't necessarily want to create a situation where the older sibling is now the parent.
Or the resentment.
And that builds the resentment. Exactly.
Like being able to be a friend and to be a true sibling and have a good relationship. That's one of the things that we talk about, and then not getting the obligatory yes. Cause right. I think that there is an obligatory yes that siblings say, and then I'm the feels. Okay, so you're legal, right? So I'm the feels, but it goes back to the hopes and dreams. And so what I ask parents to think about is, what were your hopes and dreams when you were 21 or 22? Were you capable of taking on a special needs sibling? Yep. How would that have affected you? Would you have been able to get married? Would you have graduated college? Would you have had the career that you've had? Would you have been able to fulfill your hopes and dreams? And I would say that most times the answer is no. And your answer may be different, and that is okay. But those are the things that I think about, because special needs is hard. You know this, you live this. This is your hard life. That's why you're here, because it's hard and you need some ideas and some tips and some help. And it would be hard for their sibling as well. And it definitively could affect relationships adversely where someone says, I'm not signing up for that. Sorry,
Yeah.
And so those are the things that we want you to think about as it relates to that. And I think that you just said that so well, Melissa. Thank you for that.
And so a kind of other note on that, I noticed another question. We always get questions. I'm sure Allison can attest to this too. Always getting questions. Well, what about just using the siblings? Whether it's guardian, the other question we got is, well, can't I just name the siblings as the beneficiary and not name my special needs child? Which we usually are going to advise against as well. And there's a couple of main reasons for this. So first one being asset protection and where that money is going. If we've got 4 siblings and we've got Sally who has some disability and we're needing to provide for her needs, and we give the life insurance policy to the other 3 siblings, and one gets in a car accident and one's going through a divorce, and then the other one dies and has a will that says their property goes to their spouse, suddenly special needs child doesn't have any money and nobody to provide for them because all that money's gone. So you want to have something in place whereby you're not just counting on those siblings. And then of course you can also go back to what we were talking about with the guardianship too. Even if you don't go to those, sometimes we get accused as attorneys of always going to the worst case scenario. Even if we don't go to the worst case scenario, you give the money to sibling and now still you're expecting them to use that money for their sibling, and it builds resentment. So again, you want to be careful to not over count on siblings to take care of.
And people do that to avoid having to get a special needs trust, and it's broken for more reasons than just that. But also if the individual is getting SSI and Medicaid, and so let's just say that your child or your sister or your family member that you truly trust is fantastic, and they are going to spend the money on your special needs loved one, well, that's a problem in itself because it's basically income to that person that's going to cause them to lose the SSI and Medicaid, which is why they need the special needs trust and the ABLE account. So it's not perfect, but what have seen, I've seen some really horrible situations where the individual definitely didn't get the money. Like all good intentions, but things happened and life happens no matter what. I mean, it just happens. And so I think that it's not a wise path. And then also, if you're younger and you have small special needs children and your parents are younger, and they're really spry, but as our parents are aging, so again, understand your full-time job that you have as a special needs parent and how difficult it may be if your parents are 75 or 78, or they're getting older and they're still pretty spry, but they're getting older. They may not have the capacity to handle this, but they want to because they love their grandchild and they want to, but capacity definitely diminishes as well. So basically, we come together. So I mean, kind of as you've seen today, we come together, we work with each other, and implementing the plan. So, once those legal documents are in place and we have the wording, the title, there's a tax ID set up for the special needs trust, then we work with you to change your beneficiaries on everything. And, everything that we're a part of. And then we might give you a list of check on this, and this. And don't forget that old 403B that you used to have a long time ago when you left employment 15 years ago. And, there's all these little things, these little moving parts of old employment and other things like that that you might not be thinking about that can have a beneficiary. So it is important. So on your financial radar, is just kind of sitting down and saying, hey, when's the last time we've evaluated all of this, and have we changed things since then? I would say that the majority, I hate to use the word the majority, a lot of people are in a situation where either A, they have no will, or they have a very, very outdated will. Sometimes even additional children were born since then. Nobody's kind of looked at it. A lot of people, some people have trusts or, I ran into somebody the other day and it hadn't been looked at since 1993. Well, okay, well, this Texas and these changes and the rules and the laws and all of these things, those are all moving parts. So it's important to have your documents reviewed by a specialized, attorney on these things from time to time. But if you want what you want for your loved one, it's important to have this documented. It's important to have it documented in your will, and having successor guardian for minor children and all of these things. When you don't have these things set up, then other people that you might not want to might be making decisions for you that you might not want. And so those are things that can just, to me, they can just be eliminated. So put it on your to-do list. And I'm going to start having these conversations and kind of at least talk to somebody of figuring out which direction you need to go. And not everybody needs everything. Like you said, not everybody needs guardianship. A power of attorney might just work just fine. But having those tailored conversations of you and the professional of what your unique situation is, then they can give you that customized advice. But we work together through this process, and always happy to work with the professionals that you're working with. So do we have any additional questions, Melissa?
We had a couple of additional ones, two that are in regards to guardianship that I'm just going to answer real briefly. One was asking, so you don't recommend siblings as guardians? I would say generally no. It's going to be very dependent on the situation, but it's a conversation that you want to have with your family and your attorney in making that determination. The other one was asking in regards to guardianship, does it have to be renewed every year? And the quick answer to that question is yes. You do have to submit accountings and things like that to renew that guardianship annually. The other question, which is a question for you more so, Allison, in regards to the webinar as a total, was there was a question asking if the webinar is being recorded, and if so, can they access it after this today? Someone's husband was unable to attend.
Yes. So we have recorded this today, and so later this afternoon or tomorrow, you're going to get an email. Anybody who signed up for this is going to get an email with the recording. And also in that email, we have a link to our YouTube channel. We do have a YouTube channel with other recordings and other special needs topics. So you can subscribe to the YouTube channel and pick up on any other topics that you've missed. I mean, you name it, it's out there as it relates to special needs. So we're happy for you to do that.
Oh, and Allison, I'm going to defer to you on your expertise on these webinars. We've got someone who raised their hand.
Okay.
I don't.
Okay. I have, yes. So if you will put your question in the chat box, that would be great. And then someone says, do you have flat fees for your services? And I think that the answer, probably the answer that nobody likes, is that, we do have flat fees or hourly fees depending on your situation, and because the number of people that are out here, we don't know what you need. We don't know the planning that you already have in place. We don't know what documents you already have in place. All the financials. We don't know any of those things. But what we do, we do a free initial consultation to kind of talk to you about kind of where you are, where you're going, what you need, what kind of help you need from us. And then we're able to kind of to give you a clear picture of what that looks like and how that works. What about you, Melissa?
So I will say, as a general rule, most of the work that I do with clients in planning is on a flat fee basis. We do complimentary consultations, so we will let clients know in that consultation what the fee is going to be. The only time I generally will get forced into having to bill hourly are more so court involved situations, if something is contested, or also sometimes with application processes. So if I'm dealing with a Medicaid application, sometimes we do have to do things on an hourly basis there. But from a planning perspective, the vast majority of the work that we do here at our firm, we do on a flat fee basis.
And, as a flat fee, so basically, when it comes to, if a person needs a customized plan, we need to know, we need the cash flow, we need to figure out, where the money's coming from, how we're going to fund this and stuff like that. That ends up being, a flat fee for the plan, like you're paying
Right.
for the advice. So that is accurate as well. It looks like we have one more question, and right before we wrap up. Oh, okay. So this was, are you required to file a tax return for an able or a special needs trust every year? And that is not necessarily for the able, but the special needs trust depends on what activity is going on in it, right?
Yeah, so with a special needs trust, it's going to depend on what type of special needs trust and how it was originally set up. So unfortunately, that is one of those things that we're not able to give you a straight answer on, because it is definitely the attorney answer of it depends. I'm sorry.
Right. Sorry about that. There was one last question I wanted to hit on. I think it was about the guardianship. Let me go back to it.
So there was a question about alternatives to guardianship, and I know that there have been presentations in the past that we've done on guardianship. Is that something that people would have available to them?
Yes, that presentation is out there on the YouTube channel as far as the guardianship is concerned. So you guys can look out there for that. One very last thing that I usually touch on anytime that we're talking about guardianship, power of attorney, and any of those things, is just as a one last best practice to kind of think about. Is that, your non-special needs child, your neurotypical child that's going away to college, it's a good idea to have a healthcare power of attorney and power of attorney. It's a good idea to be thinking about that in case something happens to them. And furthermore, as we're thinking or talking about these things, if you do have aging parents, this is a good time to be talking to them. While they're of sound mind and body, they're making good decisions. If something happened to you, who is your healthcare power of attorney? Have you looked at that lately? Do you even have one? Where is it? Being knowledgeable about those things. A lot of our parents don't want to talk about those types of things, but having, I just call them meaningful conversations about that before you can't. I think it is an important piece of advice. Well, we went a little bit over 3 minutes, and we try not to go over, but it has been fabulous being with you today, Melissa. We thank you for all of your insight and your help. And again, this has been recorded, and we will definitely get the recording out to everybody. And thanks so much, everyone, for joining us today.
Thank you so much for having me, Allison.
All right, thank you. Take care. Bye now.